Rhea and I have Hanifi here with me today, and we are students at the Monash Law Clinics. This video looks at the division of property after separation. A key step is to determine the asset pool of the parties. There are two parts which govern the court's jurisdiction with respect to property division under the Family Law Act. The relevant part is determined on the basis of the parties' relationship status. The court alters property interests between married couples under Section 79, subsection 1 of the Family Law Act. The equivalent provision of Section 90 SM, subsection 1 is used to alter the property interest between de facto partners. The property division process involves identifying the parties' asset pool. There may be complexities in valuing each asset in the asset pool. Parties may need to engage an expert valuer to assess the value of some of the assets. The term assets broadly refers to property that can be included into the asset pool. So what is property? Section 4 of the Family Law Act 1975 defines property as property to which parties may be entitled to, such as property in their possession. It should be noted that the assets held in a property pool may be held jointly or individually. Examples of property include real estate, business interests, cash savings, jewellery, cars, animals, shares, superannuation, and insurance policies. In stating this, it is also important to be aware of what is not included in the definition of property. Examples that fall beyond the scope of the definition include non-transferable licenses, future pension entitlements, anticipated inheritance from a living person, and unassignable rights under a trust. Alongside assets, liabilities are relevant in a determination of the parties' net asset pool. Liabilities broadly describe the debts accrued by parties during the span of their relationship. Examples of liabilities may include tax debts, mortgages, personal loans, and credit card debts. The formula to determine the net asset pool is calculated by subtracting the parties' total liabilities from their total assets. This is determined as at the date of the property division.
A party to a marriage or de facto relationship may engage in conduct that creates complexities that may require adjusting the asset pool. Examples of this type of conduct include gambling, gifting an asset, withdrawing funds from accounts, a party reducing the value of an asset, concealing property from the other party, and selling an asset without the consent of the other party before property settlement. In the event that there has been an improper divestment of assets, it may be possible that the value of the asset is added back into the asset pool. A party to a relationship may protect themselves from the divestment of assets that they may have an interest in. For example, this may be done by placing a caveat over real estate. A caveat is a mechanism that provides a warning to third parties of interest that already exist over real estate. This can operate to prevent a party to a relationship from selling the real estate and spending the proceeds without paying a share to the other party. For example, Party A and Party B are in the process of separation. Party A is registered on the title of the family home, and Party B is not. Therefore, Party B may be able to lodge a caveat that notifies potential buyers of Party B's interest in the property. For more information, please speak to your lawyer about lodging a caveat. This area is complex and it is best to obtain legal advice before lodging a caveat. In this video, we have explored the concepts of assets, liabilities, the process and formula of determining the net asset pool, examples of challenges that may arise with the asset pool, and how to protect it via caveats. Please keep a watch out for further videos in the property series by other students from the Monash Law Clinics.
For more videos, visit our website at www.vicflpn.org.au.